So who am I speaking with?
Hi, I'm Randy Shen. I'm patent counsel at Abbott Laboratories. I was approached by Peter Kellner to give a talk here at CodeCamp
Hold on, I just
because
want to point out there's Peter. Besides chair in the back.
so he wanted a little bit of a educational session on IP basic, which is intellectual property, covers patents, trademarks, copyright. It helps the everyday innovator out there to be aware of some of the risks and pitfalls of what they do.
Okay, yeah. So you were just saying you wanted to stop people from making the one classic mistake, which was,
Public disclosure. A lot of these people are very proud of their work and they want to go out and promote them so they can get some business. And that's very understandable. But what happens when you give a public disclosure is that you destroy your patent rights both here in the US potentially and definitely in a worldwide patent market. So in the US, if you have a public disclosure, you have 1 year to go and file a patent application after that public disclosure. So that's the risk of it.
that's a really good tip. Give me another like one or two big tips that every sort of inventor and entrepreneur should know.
Besides public disclosure, that's usually the biggest one. I would say for sale and public use. What people don't realize that if you offer for sale your invention without patent, again, that's a potential patent bar to getting a patent later on. Public use. So even though your software code might be in your computer, nobody has an idea what it's doing. If it's showing the results of your algorithm or what have you, that's a public use here, especially at CodeCamp. So again, don't offer for sale unless you patent it, and don't use it in public unless you patent it as well.
So should be the procedure? You keep things as secret as possible until you're ready and then patent it. And then the problem is, how long can that patent period take? Or do you just put it in for, patent pending and then go public with it? How should you handle it?
Okay, so for the everyday inventor, what I would tell you is as soon as you can, file for an application. As soon as you file for an application, you can put patent pending on it, and that gives people out there notice of a potential patent that may issue. After you file your application, you can go out and talk about it. One of the things you may also want to keep in the back of your mind is having non-disclosure agreements with third parties that you want to license. So what you don't want them to do is take your invention and start basically making improvements on it and claim it as their own. So be careful. Always sign confidential agreements in that regard, that they can't make derivatized improvements of what you tell them.
I had a confidentiality agreement, but they usually have to put a time period on it. I think I had about 5 years. I mean, uh, and that's always the case. You shouldn't sign one that's sort of an unlimited confidentiality agreement, correct?
Right. So when we talk to parties, I mean, depending on where we're coming from, we might want to put in, a year or two. Other parties might want to go for more extreme things, like you said, 5 years. I mean, that's a bit arduous in that respect because out here in tech world, Silicon Valley, you want to be able to do stuff, as immediate as possible. So think about it when you look at your non-disclosure agreements. What's the scope of it and the time length. So if you haven't signed one of these before, ask around, ask an attorney, to get a feel to what you're actually signing.